Hello, everyone. My name is Giovanni Nogales, and I'm a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Voluntary Disclosures. How should you react when something goes wrong? Our presenters are Lester Johnson and Richard Pecore. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Lester Johnson and Richard Pecore.
Hello, everyone. This is Richard Pecore. I'm here with one of our partners from the firm, Les Johnson.
Hi. How y'all doing?
And we appreciate the opportunity to speak to Home Care Association of Louisiana. Thank you all for attending. We're going to get started. We're going to be talking today about voluntary disclosures and how should your agency react when something goes wrong. So, Gio, if you would, could we advance to the first slide here? Just to give you an idea, there's two primary self-disclosure protocols we're going to be talking about. One with the OIG, which is regulatory in nature and from the enforcement angle, and then the CMS, which is an agency-sponsored, more of an encouragement protocol, the self-referral disclosure protocol, the SRDP, which Les is going to be talking about in detail. And there's a couple other self-disclosure protocols we'll mention along the way. So let's get started. First slide, please. The OIG Healthcare Fraud Self-Disclosure Protocol. It's been renamed. They did that in 2019. They basically just put healthcare in front of it. Not sure why, not really necessary, but basically it's still the SDP here. So it's available for any violation that potentially violates federal criminal, civil, or administrative laws for which civil monetary penalties apply. Now, this is going to include like the anti-kickback statute, false claims, use of excluded employees, things like that. It's not for Stark law violations per se, but it will apply to Stark law violations that do involve anti-kickback violations. So those have to be coupled. Those are reported under the CMS self-disclosure reporting protocol. This program began back in 1998. It was completely revised back in 2013, and another revision came out in November 2021. Next slide, Gio. It's available to all healthcare providers of services and supplies, including individuals and entities. They're called, the disclosure is called the disclosing party. Can disclose even if already subject to a government investigation, audit, other routine oversight activity, or even with a corporate integrity agreement. But disclosure must be made in good faith. It's not for straightforward overpayments, and it's not available for Stark violations that do not encompass anti-kickback violations, as we previously mentioned. Next slide, please. Per the 2019 amendments, it must now be submitted online using the OIG's website. This is one reason, and we'll get to this in the summary, that it is really necessary that you get counsel involved as early as possible in the process. Once you discover this, you need to be you need to either get counsel or have counsel and get in touch with them immediately, because there's a right and a wrong way to do this. And if you start off doing the wrong way, it can lead you down a lot of bad roads. Internal investigation and damages calculation must be completed within 90 days from the date of the initial submission. There's a lot of pieces to this puzzle that have to fall together. And once you start the clock, things start ticking, and that's another reason you need to have counsel involved before you start the clock. You must ensure that conduct has either ended, the conduct that you're disclosing, or for anti-kickback arrangements, that arrangement will be ended within the next 90 days or within the 90-day window. Other corrective actions should be completed at the time of disclosure. If you have other corrective actions that are pending or that need to be completed, they should be already finished. Next slide, please. All the disclosures need to have the following information: the entity name, address, phone number, and email for the disclosing party's representative, a concise statement of all relevant details of conduct relating to the types of claims, the transactions or conduct that gave rise to the disclosure, the time period involved, and the names of the individuals or entities involved and their role in that process. You need to also include a list of the federal, civil, criminal, or administrative laws that have potentially been violated. Next slide, please. You may be starting to get the impression as we go through this that you're basically creating your own admission here. So this is why you got to have counsel involved. This is why you have to be very, very careful about what you say, how you say it, when you say it, because you don't want to widen the box you're already obligated to disclose and are accounting for. You need to be able to calculate the actual damages or estimate damages under the federal program and give the total for all federal programs. If it's not yet determined, you have 90 days to figure that out. You need to describe the corrective actions that have been taken. Again, this is where your compliance plan comes into play. You should all have a compliance plan. If you don't, you have to have one. You need to get one because it's required now for everybody. And the corrective actions are what's going to allow you to track this process so that you can prove that changes and corrections have been made. Statement of knowledge of any other governmental inquiry or investigation related to the disclosed matter that is ongoing. If you have one, then list those programs and representatives involved. And per the 2019 agreements or amendments, you must disclose any corporate integrity agreement, and you can now disclose a reportable event as defined under a corporate integrity agreement. So when you get the CIA, there are a list of reportable events. If you have one of those come up, you must disclose that. Next slide, please. Again, all disclosures here need to include a minimum settle amount for disclosures, or I should say the minimum settle amounts for disclosures have gone up. If it's kickback related, it has to be at least $100,000. That's up from 50. And all other kinds of disclosures, you're talking about $20,000 or more. The rest is going to be treated either under the CMS process or it's going to fall under the category of a general overpayment. Per 2019 amendments, OIG will no longer advocate to the DOJ for the disclosing party to receive a benefit for self-reporting in criminal matters. Now OIG will only do this for civil actions. So you don't get any benefit in a criminal situation for self-disclosure. It's not going to weigh into the sentencing part. It will benefit you on the civil side. It's not for anti-kickback disclosures. As we said before, the sentencing guidelines and prosecution manuals do discuss benefits of cooperation, however. So there's no obligation to consider it, but if you have a good attorney, it's possible. Between 1998 and 2020, more than 2,200 disclosures have been made, totaling over $870 million. So you can see there's a big financial incentive for these folks to make these settlements, and that's increased from where it was originally. Originally, they weren't too predisposed to doing this. Now they're a lot more receptive, and you can actually get some concessions. Next slide, please. Let's talk about some of the kinds of situations where you'll need to consider self-disclosure protocol. False billing. In this situation, you're going to have to report on the calculation of damages in addition to the other necessary information that has to be included for all disclosures we just talked about. For false billing situations, you want to report on the calculation of damages. Either all claims or statistically valid random sample has to be employed. If using a sample, you must use at least 100 units. in your calculation. There's no minimum precision level required. There's no netting of underpayments. The report must also include the review objective, the population, the sources of data, the personnel names, titles and qualifications, and the characteristics measured. Next slide, please. For excluded individuals, and this is important because I believe this is the only tool available to address the situation of excluded individuals, because for excluded individuals, if you have one of those people that you discover, potentially every claim that was filed during the period of that person's employ, whether they were involved with touching it or not, is potentially tainted. So it has to be addressed. You want to identify the individual and any provider ID numbers, the job duties that were performed, the dates of employment and contract, the background checks that were performed before, during the employment of the contact person, the sanctions. Sanctions for the screening process include any deficiencies or breakdowns in process that led to the hiring or contracting with the excluded individual, a description of how the excluded individual was discovered, the corrective actions that were then taken, including any new or revised policies or procedures, and search the LEIE database for excluded individuals before submitting disclosure for excluded individuals. That's interesting. Why would you do that? Because you don't want to disclose an excluded individual and suddenly discover, a week later that you've got another one on the payroll. So make sure you check everyone, because if this person slipped through, it's possible you might have someone else. You want to make sure that there are no other excluded individuals involved before you make the disclosure. Next slide, please. Calculating damages. If the excluded individual was direct provider, such as a doctor or pharmacist, then detail all claims submitted during their period of employ and the amounts that were actually paid. If the individual is not a direct provider, for example, a registered nurse, therapist, a billing clerk, then you're going to estimate the total cost of employment, salary, benefit, health insurance, employer taxes, and then you're going to multiply by the revenue-based federal payer mix for the relevant time period. And then you're going to calculate damages for each federal program separately, Medicare, Medicaid, if there were any TRICARE, or even FELA, any program that the federal government's involved with, got to make a calculation separately for each one. Next slide, please. Then we have the anti-kickback situation coupled with the Stark violations. If you have a Stark violation that is affected because it's coupled with an anti-kickback statute situation, first you must explicitly acknowledge that the conduct is potential violation of the AKS and, if applicable, Stark, the self-referral law. Concise statement of all the details of the relationship or conduct, a specific analysis of why the conduct violates the AKS and Stark law, and other potential issues that need to be resolved, along with other possibles, are the relationships that are involved, fair market value of that led to the violations, what should have been paid, what actually was paid, the timing of the payments, the failure to collect payments in the contract, and how long this went on. Next slide, please. For the calculation of damages, you can use any of the methods that were described above as they are applicable. You can use another reliable method if you have one, which is then described in the disclosure. You just have to basically show your work, how you got to the calculation. If payments varied with or otherwise took into account volume or value of referrals, you want to be sure and reference that. any Stark law exceptions that are applied. Is there a safe harbor? Is there an exception to the rule that will be applicable? Is there one you thought you had, but there are going to argue that doesn't apply? This is where your lawyer is going to be coming in quite handy for you. Again, you must disclose the total amount of the remuneration, which means anything of value that exchanged hands that's involved, regardless of whether it was actually offered, paid, requested, or received. And then you have to explain the actual benefit that was received and whether any portion should not be considered to be improper and the reason why. Next slide, please. What are the potential benefits? If we have all these risks and problems and calculations associated with it, why is OIG self-disclosure protocol something we want to consider? Well, first, the OIG SDP offers a presumption against requiring a corporate integrity agreement in exchange for release of the permissive exclusion authority. So they'll drop the permissive exclusion potential penalties, and there's a whole laundry list of things they could enforce on the permissive exclusion and why you want to avoid being excluded from all federal programs. So this presumption is going to weigh in your favor. It's going to help you possibly avoid a CIA, depending on the situation. From 2008 to early 2013, the OIG resolved 235 cases by this self-disclosure protocol settlement. 234 of those cases had no CIA. That's a 99.5% rate. So again, it sure looks like the presumption is going to be applied and that you can avoid a CIA this way. The starting point for damages in this multiplier is also reduced, and this time it's half what it would normally be required, 1.5, not 3 times, plus fines as authorized in the False Claims Act. So you reduce the multiplier, you don't have the application of the FCA fines hanging over your head. Not to say this is the only potential penalty, but you have that going for you. That's the advantage. Suspends the 60-day deadline to refund an overpayment. That's really important because that's your obligation under the law otherwise. OIG will advocate for DOJ to give the benefit of the doubt on the SDP participation in civil cases. If you remember, DOJ will say that you cooperated, and that's going to weigh in your favor when they're considering referrals to the DOJ for further investigation. And most importantly, it's the only way to resolve the use of the excluded employee issue. If you have an excluded employee, this is the only way you can deal with it. So, next slide, please. The potential disadvantages, it opens the door to further government investigation, obviously, possibly revealing other conduct with penalties for that conduct. Again, why you want to get your attorney involved early, because you're going to have to do a self-audit to see if there are any other problems that were involved when you discovered this one. No immunity from liability. There's no guarantee of a benefit with the DOJ in criminal matters at all, although sentencing guidelines and prosecution say there in the manuals say there is going to be a credit of cooperation. There's just no guarantee that's going to happen. The shortened time frame to complete the investigation is 90 days from the date of submission. That's a disadvantage. Like I said, the clock starts running quickly once you trigger this. So again, your first call needs to be to counsel. You must explicitly acknowledge that conduct is a violation of laws and list all the known violations. Again, you're essentially admitting guilt here. So you want to be very careful about the wording of this so you don't broaden or imply that your potential liability is greater than it actually is. Got to have counsel for that. You're not going to be able to determine that yourself. The disclosed information is then shared with DOJ and CMS. That's going to come into application later on. Next slide, please. There is an apparent waiver of Fifth Amendment rights, but no guarantee of acceptance into the program. The Yates memo at DOJ and the responsible corporate officer doctrine complicate the use of this protocol. These are memos that have been out for quite some time. There's been a couple of them, but basically there's just further complications. There's not an easy process to this. There's a lot of moving parts, a lot of factors to it. Your attorney will know what's going on with it if they're a qualified healthcare attorney. Any admissions that you make are not privileged. Again, this is why you want to be very careful about what you do admit to. Plaintiff firms should seek admissions under FOIA. Submitting party should identify upfront any portion that it believes is protected from disclosure under the Freedom of Information Act. And note that many states have implemented many SDPs of their own. If the disclosure turns out to be strictly Medicaid, you're going to have to deal with the state aspect too. And the attachments we've included, the handouts, are an example of what Texas has done, and it will give you an idea of what they do on the state level. Les, do you have anything to add to the first portion before you pick up and start talking about the CMS program?
Well, I mean, a lot of it's going to be similar. I would say one of the big protections that you have in either of these when using a counsel really is to have them make that call as to whether or not something is, yes, a violation of law or no. And it's not because not necessarily because we are better at that than you. It's so they can't claim that it's just a self-serving decision on, in your own favor if you were to decide on your own that, something is, say, not a violation of law. You'll have more protection and possibly even like advice of counsel defense available to you if we're wrong. It's worse if you're wrong by yourself. That's what you pay us for in some cases. So to me, it's a really difficult decision anytime it's a kind of gray area situation where like medical necessity is really difficult to self-report. So if you have doubts about medical necessity, sometimes it's just hard to say whether or not that actually, it can be overpaid because you may have not documented the medical necessity of the care you're providing adequately, but that doesn't mean it's a false claim or a criminal violation. So, but there are scenarios when you might have to report something like that if there's just, memos come to light internal that, all of your managers are just intentionally admitting people into, say, hospice or home health, knowing that they don't qualify, that would be one of the situations where it may apply. But usually there's going to be other bigger problems like kickbacks that are being paid to medical directors or someone, or other referring physicians that'll be kind of coupled with it. But when it's just straight documentation and things like that, it really can be difficult to determine. But then again, sometimes you have a systemic error that's definitely not criminal, might be civil false claim because it's really systematic and systemic, and it just happened all the time. That's really where you get into a gray area, and I wish they had a better process for all of this because there is no good answer, I feel like. But obviously, if something does come up later, it's better for anyone who's taken advantage of these processes than if you hadn't. It's just a difficult situation to get into, but it's not appropriate for most just plain overpayments or documentation problems. Those are just overpayments, and you disclose and report and refund on those too, but you don't have to use these two much more serious disclosure methods that we're talking about today. So you can go to the next slide. We can start the Stark Law part. It'll be similar. The two are, to me, the OIGs is more sophisticated and it's older. it's more sophisticated from a, I guess, a portal standpoint, how you actually go about submitting it. But CMS has recently revised theirs to be a little more sophisticated and directed when it comes to how exactly you go about submitting, or at least they've adopted a bunch of forms that help focus your attention on the right issues. So you can go to the next slide and start it. So Stark Law, very similar to anti-kickback, but also very, very different. If you recall, it only applies to physician referrals, can be nurse practitioners too, but only for the making referrals for certain designated health services, of which most of home health is part of, like outpatient drugs and outpatient therapy, home health itself. It's all designated health services. So so it's only for services payable by Medicare to an entity to which he or she, the referring physician, has a financial relationship, either ownership, investment, or compensation. So it's a blanket ban against referring to anything where you have an ownership, investment, or compensation relationship, unless an exception applies. So that's where it's different, or it's most significantly different from anti-kickback statute. Is it's, one starts off with just a blanket ban and then has exceptions, and the other starts off, well, it's an intent-based statute. So you haven't violated it until you possess that improper intent. But Stark Law it's supposed to be a black and white statute that's easy to interpret. That's comical because it's probably the most difficult one to interpret out of everything that isn't like a Medicaid financing regulation. So it's a mess, but we have a lot of guidance on it, so we have a decent understanding of how it applies. So that's the fair part. It prohibits the submitting of a claim. So just everything that is a prohibited bill pursuant to a prohibited referral is an overpayment. So there's 30 exceptions. They're specific in general. They're really complicated at times. They apply to ownership, investment, and compensation relationships. There's different kinds of exceptions for each. Another huge difference between this and anti-kickback is this is only civil. There's no criminal penalties, but they're very, very, very harsh civil penalties, and it's draconian in kind of how its remedy plays out, because you may not even know that you're violating Stark Law, but because it's strict liability, you could have 5, 6, 7 years of violations. So your penalties can add up to just astronomical amounts that usually wouldn't be enforced in full against someone, but they could. So you unfortunately, you're forced to play ball anytime you get caught violating either one of these statutes. But especially Stark Law, because it can be black and white at times. And when you violate it, or you don't meet every single portion of an exception, then you're doomed. All of your, effective referrals are overpayments. So let's go to the next slide. All right, so the CMS's self-referral disclosure protocol began in 2010 under the Affordable Care Act. It's only for Stark Law referrals, not the anti-kickback and Stark, and don't make disclosures under both protocols. One of the real keys is just making damn sure that you actually have violated Stark Law or anti-kickback before you use either one of these. You do not want to try to use this as we think we maybe violated the law, but also think this exception, or under anti-kickback, this safe harbor or exception might apply. You're admitting absolute guilt, guilt in it, and it really doesn't matter if an exception or safe harbor would have applied. You're agreeing that it doesn't, and that you did violate the law when you start this process. So that's kind of where Richard was saying, it's, once you start, you're stuck in this process, and you've admitted guilt. Whereas if they just found out about something and started investigating, they may not be able to prove a case, either civil or criminal. This gets rid of that possibility. There will be no winning for you on the end, other than it may cost you a lot less. So for things that are truly innocent but are definitely violations, which sometimes happens under Stark, you may not have renewed your lease, or you may have let it roll over too many times, and that can be a violation. Those are the kinds of situations where under a Stark only referral, you don't necessarily have improper intent. It can be inadvertent kind of failure to meet an exception. Those are the ones where I think these disclosure protocols are best suited, because sometimes in those cases they won't penalize you at all, like none. But again, it's hard to even blame someone for those kinds of violations because there's no improper intent involved. It's an accident. So anything they would take from you would be, it would be a windfall for them. But if you didn't do this self-disclosure protocol, they very well may enforce that against you fully. So, and they have many times. But like the OIG's disclosure protocol, you can disclose even if you're under investigation or under a CIA. But again, it's got to be made in good faith. So you can't have the FBI come and raid your offices and then all of a sudden the next day you submit a big self-disclosure, or they, any other investigative branch comes and confronts you about something. You can't do it just to get credit after the fact when you've been hiding something. So you can, I guess, through the investigation, discover something and then make a good faith disclosure, but you can't really do it if you've, say, been trying to hide it. You knew about it all along, didn't want to be found out, and then they came knocking, so now let's disclose. That would be, I guess, something that's not in good faith. All disclosures are submitted electronically. That's always been the case with them. Used to, you could, with the other OIG protocol, you would be mailing in things, but they've always done this electronically. Go to the next slide. So 2017, since 2017, you have to use a series of really specific forms supplied by CMS. I'm guessing what happened is they got tired of people just writing generally about their corporate structure or their contracts and really not focusing in on anything that mattered to CMS. So previously the rules were just the contents that were required of it. Now the forms just go through step by step each and every single issue that it wants you to discuss. It's not all check the box. There are things you don't have to write actual explanations and attach supporting documentation, but it forces you to go through all of the required content that previously they just told you about. Upon receipt, you'll get an automatic response acknowledging your submission. That email is what suspends your repayment deadline for any regular repayment obligations, and it'll prevent any false claims from popping up when you don't. Now that'll keep going until you're basically finished with the process, or you have a settlement agreement with them, and it'll detail your repayment schedule at that point, especially if it's large. Nothing will be a real surprise to you. They'll subsequently send a formal letter accepting or rejecting your disclosure. If they reject it, they may ask for, before they reject, they actually may ask for additional documentation and support. It's possible they may ask you to modify some of the things that you've done, some of the corrective actions you've taken, or remedial actions. So there's an approval process, and that's basically what that's about. Let's go on again. Another slide. All right, so here are the 5 forms that you have to use. You don't always have to use all 5, sometimes it's just 4, but one of them's new, the rest of them have been around for a little bit. So there's the SRDP disclosure form, which is basically the main information form, just about who you are, the history of, if there are any past STARK law violations, anti-kickback, and false claims act, anything like that. The pervasiveness of non-compliance, which is kind of newer in that they're making you really detail a little bit more about how many claims are involved, how long it went on, how obvious it was, things like that. Because if something is just a straight payment for a referral, like I'll give you $100 for every CAT scan you order at my, at my imaging center, that's not something you could just accidentally do, and it is just a straight bribe for federal business, right? So that'll be kind of weighed a little bit more harshly than other kinds of non-compliance, and so it can either be like the conduct itself that makes things worse for you, or it can be how frequent it was, how, do they believe that you were basically sticking your head in the sand trying to ignore things. This form basically goes over a lot of that kind of information. Then there's the physician information form. Usually you're submitting it for every physician involved in the disclosure, unless making a disclosure for non-compliance with the group practice definition. Now, that's one of the most complicated regulations that are part of STARK law is the group practice definition regulation. It is wildly complicated, but basically it just details all the, I guess, the features or aspects of your physician group practice, what it has to possess in order for you to qualify for in-office ancillary services exception, and it has other impacts throughout some other areas of Stark law. But you can comply with every single element of, say, the in-office ancillary services exception, and fail Stark law because you weren't actually a true group practice for purposes of Stark law, but you met the entire exception for the services you were actually rendering. So they create a new form just for the group practices. Anyway, the physician one is all about the financial relationship between the physician and the disclosing party, exactly how many referrals were made by payer and federal payer source. They only have to submit one form. This is something that's kind of clarified, a simplification. There's a concept in Stark law called stand in the shoes doctrine, where physicians will basically stand in the shoes of their physician organization. So like if you're just an owner, or there's just some physicians who are only having to be reported or part of the disclosure because they're just an owner due to this stand in the shoes doctrine or for some other reason, then you only have to submit one of these for those physicians. You don't have to go through each one because frankly, CMS doesn't want that information because it's not going to be relevant to the decision if they're only standing in the shoes. So that's a little bit simpler, I guess. But so the disclosure form, the physician information form is going to come in, and go to the next slide. The financial analysis worksheet. So this will be on every one of them. It quantifies the overpayment for each physician included in the disclosure who made referrals in violation of Stark law. So basically, it's just a separate spreadsheet that just details exactly, the overpayment amounts for each one, for each physician, and it's by federal payer. I should put private insurance on there as well, but I don't know if it puts that on there actually, but it's every federal payer would be on there, but it's their form. So good thing is you don't have to pick what goes on there; you just fill in the blanks. New in 2021, I believe, was the group practice form. So this is just to simplify things. The group practice definition is so dang complicated that it would be hard to let even lawyers in the same law firm or even the same lawyer write a description of how a particular practice meets the group practice definition and have them write it, say, in a similar way every time, or go over all the same information. It gets really complicated. So what they've done is create a big form that goes through each and every element of the group practice definition, and it kind of forces you to identify each element that's not met. It's just to focus everyone's attention, I think, but it's useful. It alleviates the need to submit separate physician financial forms for each physician as well. But again, this is only if the reason why you're disclosing is because of group practice violation. So it wouldn't be because, if you violated the, say, part of the in-office ancillary services exception, where their, say, reimbursement varied based on the volume or value of referrals, well, that's not a problem with the group practice definition. So that wouldn't be, you would have to submit separate forms there. But here, if it's only the group practice thing, then each person's individual, I guess, activity or relationship isn't as relevant, I guess. There's nothing specific to just that physician. It's specific to the entire group. So if that's what your problem is, which is a lot of the times, it'll be a problem meeting the group practice definition, which may not be quite as relevant for home health, but it's certainly a welcome addition to the program, and it'll be helpful for anyone who's dealing with that, because it focuses everything in. And I think the more you make this black and white and less emotion, less writing, more forms, the less emotion there is on the other side. And sometimes that can help, I guess, you resolve something, because there's not, say, anger on the part of the agency as much. It's just checking boxes and seeing if you filled out the right things, or to an extent. So you do have to submit the separate spreadsheet detailing info on each physician, but you're not going to have the physician information form. So anyway, that's a decent improvement. Let's go on to the next one. Look at the fifth form, certification. So This has always been around. Just the disclosing party, other officer or authorized representative, signs a certification, just saying that everything provided is truthful and based on a good faith effort to bring the matter to CMS's attention in order to resolve potential liabilities. One new improvement in 2021 is you no longer have to send a hard copy of the certification to CMS. They used to want a wet signature, but these days with electronic signatures and, well, that's just going away as something that is an absolute necessity in a lot of instances. So this is one, and now we don't have to mail in a hard copy of the certification. That was the only thing they had to mail in anyway. They just wanted that wet signature on that, but I don't think they really need that to prove that you've violated your certification if you're lying or holding back anything. I don't know how. I'm not a trial lawyer, so I don't know how evidentiary, how that would affect the evidence in a case, but apparently not enough to keep us having to do it anymore. So that's nuts. So although there's 5 forms, you don't have to feel, I guess, handcuffed. You can just submit cover letters or just any other information that you feel may be relevant to their investigation. Probably lots of providers are desperate to put a bunch of memos out there, in there showing how great they are. And I guess I wouldn't really argue against that if a client wanted to, but I don't think they're going to even look at that kind of stuff. It seems like they're making the Stark only process be more, I guess, emotionless and just formula driven. But if you think about it, that also means that these are not Stark law violations that involve what would be a traditional kickback, which is more akin to straight fraud. So lots of times the harsher Stark law violations will also be in a kickback violations, are the more egregious ones, I'd say. And so you wouldn't be under the CMS protocol at that point anyway. You'd be under the OIG one. Now there's something to remember about all of this. These laws you can violate the anti-kickback statute, you can violate Stark, and there's obviously numerous other statutes that you can violate and it'd be considered healthcare fraud. But these things can be considered, even with holding on to an overpayment too long, can be considered a form of a False Claims Act. But although you're reporting to the OIG, which is part of HHS, and CMS on the other hand, which is also a subpart kind of HHS, only the DOJ can settle False Claims Act cases or criminal cases, really. So in all cases, you're going to have to be dealing with them in some way, whether the OIG is going to be helping negotiate with them or not, or CMS would, for you to get some kind of benefit. You're going to have to be dealing with them. So if it's hardcore criminal, it might be best to just go straight to DOJ, or at least have them involved at the very beginning, because you're not going to say settle with, just because you settle with HHS doesn't mean that DOJ has to abide by that. Technically, they're supposed to in civil cases, but in criminal they took out that language where they're not necessarily going to have to give you a break. But again, like what Richard mentioned earlier, the sentencing guidelines, the prosecution manual for the DOJ, they already have separate kind of provisions in there for defendants who are being forthright with information, and if they brought the information to them first, that helps you in their deliberations as to what they're going to do, how harshly they're going to charge you, and whether or not they're going to ask for a lot of time if you pled or something. So cooperation would still be helpful, even if these disclosure protocols don't mandate the DOJ give you, significant benefits if they ever decide to bring their own action, which I really wish they'd clear that up, because it seems silly to me that you could settle with one part of the government and it not apply to, another. Especially if that's the only one that enforces the statute in court, DOJ, I mean. But it is what it is. It's been like that for a long time, and it'll continue to be that way, I assume. So let's go to the next slide. So the forms, generally, they're going to cover how the disclosure was discovered, what measures were taken to address the issue to avoid future violations, any efforts to restructure problematic relationships or arrangements. Sometimes it may take a little while, because your simple ownership of something may be what is the violation, or one of the doctors owning something may be a violation. Same thing under anti-kickback. You could have some kind of a ownership or other related or contractual agreement involved that can't be terminated immediately. So that's why you're allowed a little bit of leeway to wind things up, I guess, and restructure your problematic contracts or arrangements. But that may take a little time, for someone to sell their shares or for a sale to be approved in some states. So you're also, the forms are going to cover any similar history or conduct, prior criminal, civil, or regulatory enforcement actions, including payment suspensions. They want to see, have you had any forewarning of this exact issue and others? Are you generally a bad provider? Where if it's not this one mistake, it's some other one all the time. That'll all weigh on you, and may impact, honestly, whether you come forward and do one of these protocols. But obviously, told you, I think anytime you're given the opportunity to have a break on something, if there's any chance of it ever coming out, you're better off taken advantage of that, because there's nothing telling them to go easy on you if you didn't. There is if you took part in one of these protocols. Even if it's not mandatory, it's at least, it's at least persuasive. It helps you for sure in one way or another. So the forms also go over the existence and adequacy of any pre-existing compliance programs, whether they were just on paper in your policies or whether you actually, had a compliance plan up and operating and doing things on a regular basis. Any efforts to prevent reoccurrence, new internal controls, new training programs, increased supervision, et cetera, et cetera. So it just basically goes over all of the, I guess, things you would think it would, just like the OIG's process is very similar. This start just kind of makes you focus on the right issues. Let's go to the next slide. So description of any other appropriate notices to other government. So anyone else you're notifying of the same thing. I guess, possibly publicly traded companies may have SEC reporting obligations if something's a big deal. You may have tax implications for some of this, so you may have to notify the IRS, and I guess they'll coordinate with each other when necessary. But a lot of this is just to be forthright and upfront with everything. And the more, I don't know if this is going to be relevant to every single case. It probably won't be, and some agents probably won't care about some of the answers to some of these things, but they're going to ask every question in the sun. Trust me, I've looked at the forms. They're pretty detailed. So, and if you don't get disclosed enough, they will make you if you want to stay in the program. So any knowledge of whether a disclosed matter is under inquiry by a government agency or contract. So this is basically, have you been tipped off to it? Did you do this self-disclosure because the State Board of Medical Examiners sent you a letter, or because a quality of care, complaint was raised and it somehow, led you to identify this? So if so, you identify the contractor and the representatives involved. Disclose all other investigations and inquiries on other matters. So that would be literally anything, say, outside of healthcare fraud, payroll investigations, anything. They just want to see if, how law-abiding you are, I guess, or just to gather a ton of information on you. I mean, it's the stuff that you basically are forced to admit and disclose in both of these programs is definitely not the kind of thing that you would be doing if you had never done this process and, say, some criminal lawyer was representing you and you were just under investigation, because they generally tell you not to ever talk to anyone. It never hardly helps. I don't know if that's true, but I just know that all the other former federal prosecutors I've ever talked to said, be very, very careful when you talk to them. So that's another reason to get, counsel involved. What you may think is civil may quickly turn criminal with just, a few answers of cleverly worded questions by the other side. So it's a serious matter anytime you're doing a self-disclosure, basically. Go to the next page. So there's no specific time frame or deadline. I'm sure that makes people have a lot of heartburn sometimes when they're hoping it would be quickly. It doesn't take forever if it's very straightforward, but sometimes these things aren't just stark law violations. They're actually on a kickback as well, and there's criminal implications. So in those situations, if you gave CMS this report, they're going to give that to the DOJ. just going to happen. And the OIG, I'm sure. They all coordinate. So just assume they're always talking in all situations, not just this one. So they're going to request access to all supporting documents and financial information without attorneys asserting privilege. Sometimes you will have appropriate situations where privilege will still apply, and CMS says it'll work with your counsel to obtain information without waiving any appropriately claimed privileges, but most of them they're just waiving. So, you know, that's a big loss, I guess, you know, for you when anytime you have privilege and it's appropriate, then you like it. I mean, it's definitely always beneficial to the person being investigated or a defendant. But what I tell people, they're always trying to get through privilege, and just assume that they're going to every time you talk to your lawyers. Although you may want to only do something with a lawyer, you know, be mindful of what you put in emails and things like that. Your lawyers aren't going to commit a crime for you. You do not pay them enough for that. And, you know, so I just tell people, assume that someone's going to look at my emails one day. So we're going to do everything above board, and we're not going to powwow on how to hide something. CMS will request additional information if needed, and you're given a 30-day time period to produce it. I'm sure you can, on occasion, get extensions, but this isn't the time to just start asking for extensions right off the bat without a need. You want to show that you're prepared and you've already looked into the information, you know, in detail before you even started the process. Let's go forward. Another slide. So the outcome, they won't accept payments. So basically, you're not going to pay up front until they're finished determining how much you got to pay, basically. So don't repay while without CMS's consent. And if you do consent, they make you agree that it's not a settlement, or it's not an agreement as to the amount of loss. It doesn't relieve you of any civil, criminal, or administrative liabilities, and it doesn't offer a defense. So if they pop you with a False Claims Act, you can't say, but we already gave the money back. So another probable downside of starting this process. But again, you're trying to get mercy basically from them. So I don't know what, in some cases it may not matter that much how much you disclose. Go to the next slide. So they can reduce the amount owed for start violations, but they're not obligated to do so. So this is back to, like, if it's a really, really, really blatant kickback or, kickback type situation, even though you're reporting under Stark, they're going to probably throw the book at you, if it's just really egregious. But they're going to look at the nature and extent of their improper or illegal practice, timeliness of disclosure, your cooperation, litigation risk, financial position of the disclosing party, and any other factors they want. We put this in here. Don't forget to issue refunds to individual beneficiaries for any copays or deductibles. Sometimes they won't have them, obviously, but when you got to repay Stark law violations on the claim, you also owe back the copays you collected. Lots of people forget that. So make sure that you know that and that you're disclosing that you're going to be giving that back as well. Next slide. I think we got some charts. I was looking for the charts. So this is 2011 to 2022, just showing the aggregate amounts paid and the number of settlements each year. As you can see, there's a spike in 2016. Looks like you have a COVID dip and then a really high 2022, but I'm betting that's largely, a lot of those are cases that were started in 2021 or 2020, in 2019 when it was lower. I think it will get back to closer to 80 to 70, in that kind of range, a little bit lower, closer to the high average is what we should be normal. But all of this is increasing, and I would expect, general growth over time as we go into the future. On the next slide, it's a little bit better one. So this one shows the min and max amounts each year. And so they haven't been horrendous. Some of these probably involve over 1,000 claims and could have been far, far, far worse than 1.2 million. So, it's not like they're popping people with $30 million start self-disclosure settlements. There are $20 million ones, I believe, on the OIG's past settlements, but it looks like Stark they've seem a little bit more lenient almost. I don't know if that's true, but the patterns seem to be suggesting that here and there when you look at the numbers. But it would make sense if it's only a Stark law issue and doesn't also involve anti-kickback, then you don't have this improper intent out there to rip off the government, basically. So, you know, to me, in some ways, it makes sense. The next slide. So there are other self-disclosure problems. Some of them are new, like the HHS's grant one. This is like for, you know, COVID grants, things like that. This would be, you know, just anything considered, you know, doesn't fit within one of the other self-disclosure protocols for HHS would possibly go under this one or the federal contractor one. I'm thinking like the payers, if they commit fraud, they would be under the federal contractor self-disclosure program. So this would be people who don't submit claims but do business with the government. The grant one has permissive and mandatory disclosure, so it's a little more detailed. I think the contractor one is fairly open. There's also U.S. attorneys' offices have not self-disclosure programs, but they have guidelines for prosecutorial discretion, for the exercise of prosecutorial discretion for corporate fraud. So that's really broad, right? But it's not a real formal program, and I bet people hesitate to participate in something that's not really enforceable in any way. But some of these aren't very enforceable. So, you know, it's all about, you know you're going to get caught eventually. So and you want to be honest. So let's, you know, disclose and just get straight with the government. And that's better than not, you know, being cross with them, because you lose your business. Snap of a finger, you know, they can just suspend your number, and that'll put a lot of people out of business forever. So they're useful programs. They're real serious decisions. And they're not for just routine errors in documentation, or like, you know, someone didn't document anything, but you paid them to, and no one told them not to. That's likely not a scenario for this. Even if they didn't document a single thing, if you didn't know it, it's probably just a regular overpayment. But, you know, for all those situations, these are the programs that you'd want to look into. Let's go to the next slide. I think we're almost at the end. Yeah. So basically, it's basically what I was saying. Think through these decisions very carefully. There's no appeal rights, very short deadlines, may not even resolve any False Claims Act or civil monetary penalty, you know, issues. DOJ is still out there and can pop your butt if they want to. So, you know, outside of the civil situations, they're not even, the OIG isn't even required to advocate for you. And that was just asking. That wasn't required. You know, DOJ didn't have to listen to them, but they would at least, on civil cases, will at least ask that you be given leniency. They don't have to do that at all on criminal. I think they can, but they don't have to. So it'll depend on how egregious the violations are. And you're waiving a lot of defenses, so definitely involve counsel. I hate to, you know, do a presentation which is like hire a lawyer, hire a lawyer, hire a lawyer, but this is definitely one of those scenarios. I think that's it. So if we got any questions, 2 minutes to spare, pretty good.
On our side, I don't think we have any questions. I think this is how we're going to end.
Okay.
So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Lester Johnson and Richard Pecore. Everyone who attended today's webinar will receive a copy of the presentation slides via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to them at the screen or at us at Laos Parker. So have a great Tuesday. Thank you, guys.